And right on cue, we get all the sirens outside the building. So, all right. This is Judge Alyssa Perez resuming the civil docket for the 210th District Court civil docket for June 11th, 2025. Again, all matters being heard today are being heard in accordance with all directives regarding remote proceedings. I'll go ahead and call the next case, 2024 DCV 2248, Nessa Cordero and Johnny Galvan et al. Versus Sunrise Restaurants et al. May I have announcements, please?
Yes, Your Honor. Cole Gum on behalf of the plaintiffs.
Good morning, Your Honor. Counsel Moses Winston on behalf of defendants, Sunrise Restaurants, doing business as Denny's, and Andrea Daniela Rodriguez.
And we are set for defendants, traditional no evidence motion for partial summary judgment. Mr. Winston, you may proceed.
Thank you, Your Honor. The matter before the court is a traditional no evidence motion for summary judgment made under Rule 166A, Your Honor, where defendants submit to the court that plaintiffs failed to establish the essential elements of their claims for premises liability, direct negligence, and gross negligence. Your Honor, this is the first time I think the parties have been before this court on the merits of this case. So as you stated, I'll provide a brief overview of the facts in this case. The case, Your Honor, before the court is based on the service of coffee to a family that was dining at a Denny's in El Paso. We have plaintiff Nessa Cordero and her partner, Johnny Galvan, who are also parents to two minor children who were at the restaurant that day. So we had one older child, I believe he was about 3 at the time, and then the minor in this case, BG, was approximately 11 months old at the time of the incident. So, Your Honor, we have plaintiff Cordero testified in her deposition that they went to the Denny's, as was very customary for the family. They went to get breakfast early morning. It was about 9 a.m. Miss Cordero and her family were served by the other named defendant in this case, Miss Andrea Rodriguez, who was their server. Miss Cordero testified that Miss Rodriguez came to the table. She provided a drink order for the entire family, where Miss Cordero ordered cold drinks for her two children. She thinks it was probably juice, and for her partner, Mr. Galvan. And then she ordered a cup of coffee for herself, as she said is normal for her. After the family ordered, Miss Rodriguez came back to the table to serve the drinks. As Your Honor knows, this was all captured on surveillance video. So what we do see is it's kind of what we see on the surveillance, but also what the plaintiffs testified to. But we know that Miss Rodriguez came back to the table and served the drinks one at a time. She started with the cold drinks, served them to the table. And in his deposition, the children's father, Mr. Galvan, confirms that he saw these initial drinks being served and he began to move them around. He stated that he was making room for, the food that was going to come. But what he did say is he never saw that last drink served. So in the surveillance footage, Your Honor, we see Miss Rodriguez serves that last drink, that last cup of coffee to the table. And so so she serves the coffee, walks away, and approximately 12 seconds after Miss Rodriguez served the coffee, the minor BG grabbed the cup of coffee, pulled it to himself, and unfortunately spilled it on the front of his body. Again, we have no audio on the video, but as soon as that happens, you see both parents immediately react to BG, pick him up, try to address his injuries, and they immediately run out of the restaurant. BG suffered second-degree burns to portions of his trunk and legs, and he healed weeks later with, again, second-degree burns. In her deposition, Your Honor, Ms. Cordero testified that she didn't know that Ms. Rodriguez testified that she didn't know that BG could reach the cup of coffee from where he was seated. He was in a high chair at the head of the table. And instead, Ms. Rodriguez thought that, she had served it to the mother, Ms. Cordero, the one who had ordered the coffee. Both parents testified that they were doing something at the time the coffee was served, right? Miss Cordero was handling her other slightly older child, still a toddler, and Mr. Galvan said that he didn't see the coffee because he was moving the other drinks. So again, Your Honor, these undisputed facts and allegations, what we're arguing here is that they relate to an ordinary negligence claim, right? The cause of this injury was solely the inadvertence or mistake of Miss Rodriguez regarding where she served this coffee, right? I mean, we know that she thought that she served it to the mother, but it was a mistake. She was wrong, and the baby actually did grab the cup of coffee. And so this is why we're seeking summary judgment here, Your Honor. We're trying to get rid of the unsupported claims. And so based on these facts, we're looking at plaintiff's evidence and the facts developed to date, and we know that there aren't sufficient facts or evidence to support the essential elements of any claim for premises liability, negligent hiring, training, and supervision, or gross negligence. So I'll go through these one by one here, Your Honor, and please let me know if you have any other questions. But starting with the premises liability claim, we know it's undisputed, and plaintiffs seem to concede in their response that they can only recover under one of these theories. They can either, for these damages, they can recover under either a negligence theory or a premises liability theory. For purposes of this motion here, Your Honor, defendants submit that there's no evidence that there is a condition on the premises that involved an unreasonable risk of harm, right? Plaintiffs point to the fact that there was coffee served as a table as an unreasonable risk, but simply not the case. This is a very common condition at every diner across the United States. This is even on the date of this incident. There were other individuals in the restaurant that had coffee served to them. Typically, when we're looking at a garden variety premises liability case, we're thinking of a slick floor that no one knows about, or a pothole in an unlit parking lot. Not something that was ordered, right? Miss Cordero was the one who ordered the coffee and had it come to the table. And so again, this is something that is more sounds in negligence, right? Plaintiffs are contending that the service of the coffee fell below a standard of care, right? Miss Rodriguez should have served that in a different place where BG couldn't reach it. And again, there are facts to suggest that, but as far as this cup of coffee being an unreasonable condition on the premises of the Denny's, we don't think that there's any support for that. And so we're looking for summary judgment based on that absence of evidence on that element of the premises liability claim. Next, Your Honor, we're going to the negligent. In our motion, we seek summary judgment on plaintiff's claim for negligent hiring, training, and supervision. In the response, plaintiffs seem to suggest that they were going to non-suit the negligent hiring claim, and we're really looking only at the negligent training and supervision. But I'll look at them each briefly. Just generally, I know that Your Honor knows this, but every negligence claim requires that duty, breach, and then the cause of the injuries. And so a claim for negligent hiring, supervision, and training requires those same elements here as it relates to those specific tasks. So it should be noted, Your Honor, that plaintiffs have not identified an expert or any kind of witness to talk about what the standard of care for a food service establishment is for the hiring, training, or supervision, right? So we don't have any evidence before us that talks about that standard of care or the level of care required for Denny's. And that's, again, sometimes we can resort to common knowledge, but for this is very specific what plaintiffs are asking. They're suggesting not that the training provided there was no training provided, but rather the training was insufficient, right? And we just have no facts to suggest that. And in fact, Your Honor, the reverse is true. We know it's undisputed here that when Miss Rodriguez was hired, she had worked at a food service establishment, for a year prior. She's a very young server, but she had a year prior to coming to Denny's. And then when she got to Denny's, Your Honor, as with all employees of Denny's, she went through a comprehensive training and evaluation process before she was tasked to work and serve tables. So in this case, Ms. Rodriguez testified about reviewing videos, which is very common in the food service industry. They're not typically given a book and told to read, but rather they look at videos and they're shown the best practice on serving and food service and customer service. Ms. Rodriguez talked about during that onboarding videos that she was provided training on, specifically the service of coffee, which is the relevant training here today. And after she completed those videos, there's also on-the-job training where Ms. Rodriguez testified and described how she had to shadow a server, something we've probably all seen. You get a more experienced server come to your table with another server who's new, and maybe they take the order, maybe they do the service, and that other server looks on and determines whether or not the younger server is completing the task accordingly. And so Mr. Rodriguez talked about how she had to do this for a full week before she got her own tables and was put on the floor by herself. And so again, Your Honor, there's just no evidence here to suggest that that type of training that was provided to Ms. Rodriguez fell below any kind of standard of care. It was certainly provided. And we have no evidence to suggest that additional or even different kind of training is required in the industry. I think that right there demonstrates that there's no evidence of a breach here. More to the point is also there's no evidence that any kind of breach or the training was the cause of the injuries here. We know Ms. Rodriguez testified that she was served on the proper service of hot coffee. And again, it was simply what her testimony is. She thought she served the coffee to the mom, had no idea that the infant could grab it, and that was really the cause of the injuries. So again, with that, Your Honor, we don't have any evidence of a breach relating to the training of Ms. Rodriguez or any kind of cause stemming from the breach that caused the injuries here. Next, Your Honor, we go to the negligent supervision claim. Again, we don't have any evidence to suggest that there was any breach by Denny's or that breach caused any injuries related to the supervision of Miss Rodriguez. We know that Denny's had a general manager on duty at the time of the incident. He described how he's there to ensure that all of the employees are adhering to the training, the requirements, and the standards for those employees. And we simply know that Ms. Rodriguez served the coffee, walked away, and 12 seconds later, the BG had grabbed the cup of coffee. And so to support this claim for negligent supervision, Your Honor, the Texas courts show that you have to demonstrate that something the supervisor did fell below a standard of care. We have no evidence that what Mr. Borges was doing at the time was inappropriate or not in conformity with industry standards. Or more importantly, Your Honor, what the courts say is that if he had done something differently, he would have come in and stopped the incident. We have no evidence of that at all. And instead, we know that Miss Rodriguez was supervised at the time of the incident, and it's simply inadvertence was the cause of the incident here. And so, in sum, Your Honor, we have undisputed facts show that Ms. Rodriguez was properly hired, trained, and supervised. We have no evidence to the contrary, other than simply argument that there could have been different types of training or supervision provided. But again, this is not through any testimony of a witness, but simply just argument. And so again, based on these facts, Your Honor, we think that summary judgment in favor of defendants is proper on these direct negligence claims against Denny's. Finally, Your Honor, we move to the gross negligence claim. Again, what we've described here today is simply just an ordinary negligence claim, and we know the courts in Texas require that there is a functional difference in between an ordinary negligence claim and a gross negligence claim. And so to support that claim in Texas, we know the plaintiff has to prove all elements of negligence, which is the duty, breach, and causation, but also two additional elements, which we look at is the first. Sometimes these are called the objective and subjective prong for gross negligence. First, the plaintiff must show that the service of coffee involves an extreme degree of risk, right? Where the likelihood of injury is evident, and it's not an injury may happen, but a heightened standard of injury is likely to happen from this type of activity. And so we're looking again, the relevant fact here is the service of coffee. And so plaintiffs have to offer proof that this involves an extreme degree of risk. And next, Your Honor, only if plaintiffs establish that first prong, they next have to prove the second prong, which is the subjective view of the activity. And so the Texas courts show that plaintiffs are required to show that Denny's or Rodriguez knew of an extreme degree of risk, but proceeded with conscious indifference, right? They knew something was risky, but didn't care about the rights or safety of the plaintiffs, and that caused the injuries. And so, again, Your Honor, we just have no facts to support this, no evidence in the record to support either of these prongs. First, the service of coffee, again, does not involve the extreme degree of risk. This is something that happens all over the country, several millions of times a day. And in fact, this was only done because the plaintiff ordered this, right? This wasn't something that was brought upon her, or this wasn't a sparkler at a restaurant with an infant. This was just simply a coffee at a breakfast restaurant. This is not an extreme degree of risk. Plaintiffs point to the opinion of their expert, Dr. Romanos, but even in his affidavit, he has not been deposed yet, but even in his affidavit, he doesn't call this an extreme degree of risk. He says that this is the coffee is a dangerous condition, which, again, even if that were true, I think we could also say that a butter knife there is a dangerous object, right? If it's used inappropriately, that could be it. But it's certainly not rising to that level in an extreme degree of risk related to the service of coffee to a table with two parents, presumably watching over their children. It's just not something that the Texas courts have looked at to say that this is going to be highly dangerous, which is what's required for gross negligence. Typically, we have cases involving, high-speed driving, driving under the influence, driving after a mechanical failure, all of those things where objectively we think, yes, something is likely going to happen from this. Someone speeding, going 90 miles an hour in a 45. That's objectively an extreme degree of risk, and as the Texas Supreme Court requires, highly dangerous. But in this case, that first prong is not met. Next, Your Honor, we go to, even if you were to find that the first prong was met, we look to the second prong, which is the subjective view of the activity. And so what we need here is to prove that Rodriguez, through her acts or omissions, knew there was an extreme degree of risk associated with her service of coffee, but proceeded anyway. We know this is not met here. Plaintiff's counsel in the deposition when he was deposing Ms. Rodriguez asked her point blank, did you know at that time about the service of coffee? Was there a risk to BG at this time? And she said no. She said, I thought I served it to the mother, or that was my intention. I was serving it to the mother. I had no idea BG could grab it from there, right? She just did not know. And in fact, Your Honor, she says a little more, and I put this in the reply, but she talks specifically about what she knew at the time of service, and what she says here, Your Honor. She says, due to the circumstances, this is quote in her deposition, due to the circumstances and the situation of how the layout was, talking about the table, and how the kids were, I believe that was the best place that I could have put the coffee, because any other place would have been harmful. So this is not something where she just served it there and I was rushing to get back. I didn't care where it was. It was, she consciously knew that there was a table with two very young children, and she placed it somewhere where she thought only the mother could reach. And so again, we see that on the video. We see that through testimony, and even when Miss Cordero was deposed, she said, no, I don't think this is intentional, right? She just didn't know. She placed it there, didn't know. And that's, again, what we look at, these acts by Ms. Rodriguez do not suggest that she didn't care. She knew that the baby could reach it, but didn't care and place it there. Just simply does not rise to that level of intentional or reckless behavior necessary for gross negligence. And then finally, Your Honor, we'll get to the gross negligence claim against Denny's. We know a corporation has to act in and of itself as grossly negligent, or one of its vice principals, higher level management doing that. No one else is involved in this incident, Your Honor. It was simply Ms. Rodriguez and the family there. Denny's trained its employees to avoid placing coffee within the reach of a minor child, and unfortunately that simply didn't happen simply by the mistake here. And when we look at the Supreme Court finding in the U-Haul versus Waldrop case, it's very clear that gross negligence cannot be based on an act or omission that is merely thoughtless or careless, which is all we have here today. And so, Your Honor, with that, those are the arguments that relates to these claims that are not supported by the facts in this case. would ask for summary judgment based on the fact of the absence of evidence to support these essential elements of these claims and narrow the issues here for trial based on the facts developed in the record. And I'll stand for any questions the court may have.
I don't have any at this time, Mr. Winston. Mr. Gum, you may respond.
Thank you.
Yes, Your Honor, thank you. Just a couple additional facts that I do think are relevant to the court's inquiry. First is the placement of the coffee cup. And so I'm not sure if through Zoom I'm able to share my screen, but I do have a screenshot of the video that if the court would allow it.
Be able to, so if you need to, feel free.
Okay. And so, Your Honor, can you see my screen here?
Yes, I can.
So this is defendant Rodriguez here. This is minor BG, and this is the subject coffee cup. And so I want the court to at least be able to appreciate where did Miss Rodriguez place the coffee cup at the time this incident occurred, because I think that's very relevant. And I will stop sharing. And I think the second fact that is important is that both plaintiffs, the adult parents, have been deposed, and they both testified that defendant Rodriguez did not provide any warning or indicate that she was serving that hot coffee. What the video would show is the service of the cold drinks was done. Ms. Rodriguez put the server tray on the table behind Ms. Cordero, and she went back and grabbed the cold drinks, placed them on the table, and then left the table to go back to the server or to the tray. And so at that instant, my clients did not have any subjective awareness or understanding that Ms. Rodriguez had the hot coffee with her. At that point, they then start serving the cold drinks out, at which point Ms. Rodriguez comes back with the coffee cup, places it in front of the minor BG, and as our clients have testified, or my clients have testified, never said anything to the parents about, hey, I'm putting this coffee cup here, or where would you like me to place it? And again, I just think those are some additional facts that kind of give some more light on what my clients and Ms. Rodriguez were doing at the time of this incident. And so to get to the substance of defendant's motion, as the court knows, the defendants have the burden of this as the movant, and the court has to view all evidence in light most favorable to us as the non-movant. And any reasonable inferences must be resolved in favor of us. And so in our response, I believe the first thing that we outlined are our objections first to the timeliness of any of the no evidence portions of this motion. We currently have 12 depositions outstanding, which have been scheduled or are in the process of being scheduled. We have 4 treating doctors that are we're not sure if they're all going to show up on Friday, but we have those scheduled for Friday. We have 2 liability experts, theirs and ours, that are going to be deposed, as well as 6 additional experts. And so we would object to the timeliness of the no evidence motion. And then furthermore, we objected to the defendant's expert report. It's not an admissible format, and therefore is not proper summary judgment evidence, and the court should disregard anything stated in the expert report. As it pertains to the negligence versus premises liability claim, the defendants in their own motion concede this is a negligence case. And so it's not the subject of this motion, and so we believe, therefore, the negligence claims absolutely move forward. As it pertains to the premises liability claim, it's clear from Texas law that this is a premises liability claim and not a negligence claim. In Brooks v. PRH Investments, that's a case where a lady was injured at a restaurant and she slipped on a wet floor. And the court there stated that the negligent activity ceased to continue once the employee stopped mopping the floor, at which point the dangerous condition was the wet floor, which is ultimately why they agreed it was a premises claim and not a negligent activity claim. I will state to this court that we do concede that we can only recover under one of those 2 theories, but it would be improper to dismiss the premises claim, which is the only subject of this motion, whether it be by directed verdict or at the charge conference. Obviously, once the evidence has been put on, that's when we can, the court can really make a decision on which one stays or goes. But I think it's very clear by precedent that this is a premises liability claim. As Mr. Winston mentioned, there are a few seconds that pass between the time Ms. Rodriguez put the coffee cup down to the ultimate injury producing event. Those few seconds is when it turned from a negligent activity into a premises liability claim. And as it pertains to the premises claim, I believe we survive, and there's significant evidence. The first element is that the premises owner, that there was an unreasonably dangerous condition on the premises. We have the video itself, which speaks to the hot coffee being placed in front of the child. Denny's has its own policy that states that hot beverages should never, in all caps, be placed within the reach of a young child due to the risk it poses. There's significant deposition testimony showing that the defendants, including their corporate representative, Sunrise Restaurants owns about 200 Denny's franchises. And so while it is a franchise, they have a very large presence in the Denny's business. And their own corporate representative testified that hot coffee can be dangerous. Placing it in front of a child can be very dangerous. So they understood that risk, and obviously that would give credence to this being a dangerous condition. And then we have our own liability expert who has concluded that the placement created an unreasonable hazard. And then next, the next element we have to prove is that they had actual or constructive knowledge. Here they created the hazard. Defendant Rodriguez placed that coffee cup down. Whether she subjectively knew it or not, she's charged with that constructive knowledge by creating the condition. And so we would state that there's very clear evidence that they did have constructive knowledge of the dangerous condition. And then we also have to prove that the owner did not exercise reasonable care to reduce or eliminate the risk. And so I think the fact that our clients testify there was no warning or statement about, hey, I'm placing this coffee cup here, I think that shows that they failed to exercise reasonable care, as well as not doing anything once the coffee cup's placed. They don't do anything to cure the dangerous condition. And so there's a failure to warn, and there's a failure to take affirmative steps to cure the dangerous condition. And finally, proximately causes our client's injuries. Clearly, ultimately, our client was life flighted from El Paso to Lubbock and stayed in the Children's Medical Center in Lubbock in the burn unit. And so obviously the hot coffee was the proximate cause of our injuries. Next, as to the negligent supervision and negligent training claims, I believe, Your Honor, that our negligence claims are, I would agree with Mr. Winston that the negligent supervision claim may not survive. I agree that Mr. Borges, who was the general manager, who was on duty at the restaurant at the time, there is no evidence to state that he was negligently supervising Ms. Rodriguez at the time this incident occurred. However, I think the negligent supervision really goes to the negligent training. Mr. Borges testified that prior to this deposition, he had never seen the policy regarding hot beverages until the day before the deposition. There was only one produced policy regarding the services of hot beverages, and so we can rely on the defendant's own production that is the only policy regarding the service of hot beverages, and that's the policy that their own general manager says, I don't know if I've ever seen this until the day before the deposition when he's preparing for that deposition. I know Mr. Winston mentioned, whether we don't have an expert to talk about the duty regarding, what standard of care they're held to. Obviously, the question of duty is a question of law, and I think there's no doubt that an employer has a duty to properly train its employees and properly supervise. But again, I agree that the supervision is not there. The training, Mr. Borges had a failure to properly train and be aware of the own policies of Denny's. If I'm correct, I believe Mr. Borges had been the general manager of this store's location for approximately 2 to 3 years prior to this incident. And so to not see that policy would be some evidence of a negligent training. And then the specific waitress here, Defendant Rodriguez, when asked if her basic food safety training course included anything about the training of service of hot beverages, she said she didn't know. There's very scant training that's done with these waitresses. She testified that each course takes less than an hour, and in deposition, she really has very little memory of what was actually trained during these videos. And so it would be our position that if someone's properly trained, especially on something like the service of hot coffee, which Denny's own corporate representative testified is one of its largest selling goods, if they don't know whether they've been trained on something, that is some evidence that they haven't been trained properly. And so I would point the court to, in my deposition testimony or Ms. Rodriguez's deposition testimony. I try to ask her in several different ways, what specifically were you trained on? And it's very much, I don't know, I don't remember. Yeah, I agree, I shouldn't put stuff in front of a hot beverage in front of a baby. And so I believe there is some evidence that there was negligent training. And then as it pertains, taking that step further to the gross negligence standpoint, objectively not knowing your own policies and training and not knowing what's constituted in the trainings would be objectively risky, specific as it pertains to the service of hot coffee with a diner that is notorious for serving hot coffee. If they don't know their own policies and their own training, I would contend that's objectively risky, and then it's subjectively risky as well. It's a conscious disregard of understanding your own proper policies and understanding what needs to be done to train on those policies. And so we would argue that the gross negligence claims do exist and should continue to trial against Denny's. I will concede that I do not believe or have any evidence that at the time Ms. Rodriguez placed the coffee cup that she subjectively had it was not intentional. She was not subjectively intending on what the result of that. But I will say that, again, it's conscious disregard. It's reckless behavior. You know that serving coffee in front of a baby is risky. She knows the baby's there. She knows she's serving the hot coffee where she's serving it. And I think from the video and the placement of the video, you can tell it's very clear that is within reach of the young child. And even their own general manager, Mr. Borges, admits that was within reach of the young child. So for those reasons, we believe that both premises and negligence claims should stay. The direct negligent training claim against the company should exist and continue forward, as well as the gross negligence claims. Thank you, Your Honor.
Thank you. Mr. Winston, you have a bit of a response, and
Just very brief. Yes.
In terms of the objection to the expert exhibit, do you have a response to that?
No, Your Honor, I agree with Mr. Cole. Simply what we refer to in the expert report is that coffee is served millions of times a day. I think the court can take judicial notice of that or use their own experience to determine that that's what it is. There was nothing else in there about from his opinion other than the fact that he said that this is a common occurrence.
And I would also sustain Mr. Gumb's objection to that. Go ahead, Mr. Winston.
Thank you, Your Honor. Just very briefly, just to touch on a few notes. I don't want to get too far in the weeds here on the policy here, but I think it is important to kind of go into what this was. So Mr. Borges was shown a page document that our corporate representative explained. This is a training protocol. This document is not, as I stated before, this isn't given to the employees as a way to say this is how you're trained. This is something that trainers use to train the employees. So the fact that he had never seen that document is certainly not relevant, but it's not evidence of the fact that Ms. Rodriguez was not trained. She stated repeatedly she knew what the policy was. She thought that she conformed with the policy by placing the cup to the mother. We have that screenshot of the service, Your Honor, and it should be noted that the mother is right there. I mean, it is just as close to the mother it is to the child there. And again, these are factual issues, but I think what we're looking at more here, Your Honor, is there's no evidence that she was not trained. If we're talking about the adequacy of training or that there should have been different types of training, we do need an expert to say that. We can't just have the argument that something else was required, because this is not, one, we know we met the standard for training set by Denny's, but also that's not the standard there. It's industry wide, right? And so we need someone to come and say, industry wide, this is the standard of care for training employees, and we simply don't have that. We can't just allow a jury to surmise that something else could be done or have that kind of statement made without a qualified expert testifying to that. And lastly, Your Honor, on the gross negligence, again, when we look at the jurisprudence in Texas about what's required for gross negligence, this is not something that's common. It's never something that is a matter of course. If we're going to say that the service of coffee is unreasonably dangerous and involves an extreme degree of harm, everything would be a gross negligence claim, Your Honor. It simply would just swallow the rule here that requires a heightened standard for this type of gross negligence. We know that there should be some kind of distinction between ordinary negligence and gross negligence. The Supreme Court says that this needs to be highly dangerous. It's certainly not highly dangerous here in this instance. Ms. Cordero is the one who ordered the coffee. I don't think she would subject her child to something that's highly dangerous. And so for that, Your Honor, I think we have established there's not any evidence in the record to support these prongs here for gross negligence or the negligent training, hiring, or supervision of Ms. Rodriguez, Your Honor.
All right. Mr. Gum, anything else? You're muted.
I have nothing further, Your Honor.
All right, gentlemen, thank you very much. I do have to do some work on my own to review some of the items that were attached and provided by you all. But thank you for your arguments. They were very clear. I don't have any questions at this time. I do think that I see we have our next setting isn't until July 16th. I don't anticipate taking up until that date to rule. I certainly would like to get to it before the end of this month, but it may take me a minute just to make sure I'm thorough. In the event I need y'all to come back, we'll let you know, but I doubt that's necessary. So thank you. Unless you have something else for the court, then you all are excused.
Thank you, Your Honor.
One thing, Your Honor, if I may, I think we may try to get a status conference on extending some deadlines. I think, Mr. Cole, we mentioned that, and so I don't know your preference on getting before you regarding some scheduling and certainly the current trial setting in September.
I would just jump in and say, Your Honor, that I think we've worked well together, and I don't see that being a problem that we can't work out directly with ourselves unless the court would like to be involved.
So I'm happy to. What are you all thinking? Are you thinking you need to go past September, or?
Well, as we stated, and I don't want to take too much of the court's time at this point because I know we're set for this, but we are still looking at depositions till the end of July, possibly into August. And so if we know that we're going on in September, I think we need to look to see. And if we're not set, or the court doesn't think this is going to be heard in September, that may help us determine what we need to do in terms of next steps. So again, it may be helpful to at least get the court schedule and where we are on the docket.
So a couple of things. We have the final status conference on July 16th. So that'll give us, well, but I think, no, that's my docket call day on the next case that's coming up. So we can keep that. Certainly we can talk about it more then. Your final civil pretrial. Have you all gone to mediation?
We have.
Okay. So yeah, we have a couple of dates beforehand, and certainly if you all have an idea, a better idea, present it to the court. I think I'm flexible. So you all let me know. Okay. But we'll take care of this first. All right.
Thank you, Your Honor.
Thank you, Your Honor.
Good time. Have a good day.
Good to see you, Moses. Take care.
Thank you, Cole.
All right.
You want me to go ahead and bring everybody else in for the last one?
Let me just make sure. Walter, do you need a break? Because I know the next one's a doozy.
Yeah, we have 5 minutes, Judge.
Absolutely. Thank you.
Hello, we'll be with you shortly.
Thank you.
All right, Mr. Nanez, good afternoon. Good morning, gentlemen.
Good morning. Good morning, Judge.
Mr. Nanez, if you would please get us on YouTube and we'll get started. Just wanted to be clear. I have two motions for summary judgment, RV Share and My Universe. Is that right?
Yes, Your Honor.
Okay,
Right, Judge.
I think we'll start with My Universe. Let's just get on YouTube.
We're on, Judge.
Oh, okay. I never get the little notice. Oh, there. Okay, good morning. This is Judge Alyssa Perez resuming the civil docket for the 210th District Court, June 11th, 2025. I'll call our next case, 2022 DCV 0886, Eduardo Cabral et al. Versus My Universe et al. May I have announcements, please?
It's Brennan Villanueva and Nicholas Bruno, my co-counsel, here on behalf of the plaintiffs.
Good morning.
Your Honor, Carlos Rincon and Brian Cathy here on behalf of Landstar, and Mr. Cathy will be presenting the argument today.
Thank you.
Sebastian Nunez here on behalf of defendant RV Share.
And Your Honor, Aldo Lopez on behalf of My Universe, Inc. and Kush Paul Singh.
All right, so Mr. Lopez, you may proceed on your motion.
Thank you, Your Honor. Your Honor, we filed a motion for traditional and no evidence summary judgment in this in this case, and this isn't in the main case. This is actually on a cross claim that's been filed by Landstar Ranger against my clients for indemnification related to this accident. My universe has actually settled with the plaintiffs, so this is the only claim that's still pending regarding our clients. And I would point out to the court also, we have filed a motion to sever and abate this claim against us. That's still pending. And really, Judge, so the summary judgment is based on, or the traditional summary judgment is based on the deposition testimony of the corporate representative and the agreement that's been submitted. The corporate representative testified that he didn't recall signing the agreement, and the agreement that's been submitted as exhibits to this case isn't a signed agreement. It was an electronically signed document, or purported to be signed electronically. What the defense has submitted is a exhibit with a check mark next to it saying that my universe signed the document. So the traditional motion for summary judgment is based on the testimony of my universe's corporate rep that he doesn't recall signing it, as well as the fact that there's just no signature on the document itself. The no evidence motion for summary judgment is along those same lines, where we've asserted that there was no offer, no signature, no meeting of the minds, and no intent that the contract be mutually binding. The defendant in this case has, as their response, has said, well, they worked for 2 years, so this contract is binding against them. We concede that the work done by Universe does show that there was an agreement to provide services. We don't concede that that establishes that this specific contract is at issue, which would contain the indemnification clause that Landstar has based their cross claim on. Landstar submitted an affidavit from a corporate rep saying he's familiar with the procedures and how these records are maintained. The problem with that, and why it's not sufficient to defeat the no evidence motion for summary judgment, is this is an electronic signature, Judge, and under the Uniform Electronic Transaction Act, a party who is attempting to establish that the signature belongs to somebody has to testify regarding the efficacy of the security procedures used in that electronic signing, and that's completely absent from the affidavit of Landstar corporate rep. And Your Honor, so I would cite the court to Houston AN USA Shattenkirk 693 Southwest 3rd 513, and that's citing to Aerotech Inc. 624 Southwest 3rd at 204, which is a Texas Supreme Court case that says if you're trying to establish the electronic signature, you have to provide how you're tying this person's signature to the electronic document that you're trying to use. And we just don't have that in the affidavit, Judge. So those are the bases for the MSJ. One housekeeping issue on our end, Judge. The defendants also pointed out we did file a verified denial in this case. However, it was missing a signature. And so defendants have said, well, we can't oppose their defense without that verified denial. So the plaintiffs would ask leave of court to submit that signature.
Well, Mr. Villanueva, are you?
Your Honor, Brian Cathy on behalf of Landstar, I will be responding. I don't want to cut Mr. Villanueva off, but I don't think he has a response to it. I think it's directed at my client.
Wrong attorney, Mr. Cathy.
No problem, Your Honor.
On the motion for leave, I gotta assume I know what your answer is, but I'll hear it.
Yes. So, I mean, just to be clear, Your Honor, they filed their original answer in December of 2023. They didn't deny execution of this agreement. They filed an amended answer in September of 2024. They didn't file a verification. Then in May of this year, they filed a supplemental answer and they attempted to include a verification, but they didn't attach it. And, you know, I think to the extent they want to now seek leave to obtain that affidavit, it's a sham affidavit. We already deposed their corporate rep who didn't deny that he executed. He said, yes, I can't remember it. But he also simultaneously did not deny the authenticity of the signature on the contract. And so that's the core issue, Your Honor. There's a threshold procedural question before the court, and that is without a valid, timely verification denying the execution of the agreement, they can't proceed on that basis. Rule 93.7 says in the absence of a timely sworn plea, the endorsement on it is fully proved. So for the last 2+ years of this litigation, the authenticity of this has not been controverted, and it's been fully proved under Rule 93. And so, you know, there's been no testimony that this was not electronically signed. The only testimony that has been provided was that the gentleman did not, quote unquote, remember signing it. But we provided the court with at least 2 El Paso Court of Appeals decisions that make clear that merely attesting that you don't remember a signature does not create a fact issue as to the authenticity of the signature. That's the INRI December 9 company decision we cited, and then simultaneously or later the court reaffirmed that in INRI V&A. And the point of that is, Your Honor, it can be simultaneously true that you don't remember signing something and that you actually signed it. And so that's why the mere verification that somebody doesn't remember signing something is insufficient as a matter of law to create a fact issue. Beyond that, Your Honor, we did provide the affidavit from a Landstar representative that did testify to the authenticity of the document. The whole notion of security procedures under the Electronic Transactions Act wasn't raised in the plaintiff's motion. And to the extent it even were raised, the issue's moot because the plaintiff's, the corporate rep for My Universe didn't deny that it's his signature that's reflected on the document. And so you have substantive and procedural issues that fully prevent the court from considering it. And frankly, it's not an issue that I think leave should be granted on to try and create a non-existent fact issue. And, you know, opposing counsel also referenced performance under the agreement. My Universe clearly had understanding of the existence of this document. In fact, their corporate rep testified that his signature appears on it. But beyond that, I mean, it's basic, you know, 1L contract law that you can have a unilateral contract that's executed by performance. And in this case, they clearly performed under the document. The claims against my client are derived from My Universe's performance under that document. And so they're stopped as a matter of law from trying to contest the authenticity of this agreement under which, you know, they owe indemnity. And so for all those reasons, Your Honor, I think they're procedurally barred, but also substantively barred from trying to change course at this late hour and inject, you know, a non-existent fact issue into the case.
Mr. Lopez?
Your Honor, just real briefly. So I think this is a little bit different because we don't have a physical signature, and it's the, you know, defendant's burden to raise a fact issue as far as the no evidence summary judgment goes as to the signature. And by not providing what's required, any kind of requirement under to prove a electronic signature, they failed to raise a fact issue on that point. And I think a no evidence motion for summary judgment should be granted on those grounds.
Okay. Right. I'm going to hold off there for now. Let me move on. Did you have, let's move on to RV share.
Judge Sebastian Nunez here on behalf of RV Share. Now, our issue may be a little bit more, I guess, easier to rule on, if I may, Judge. So we filed our motion for summary judgment against plaintiff's claims, and in response to our motion for summary judgment, plaintiff's counsel in his office filed a response indicating that they're not opposed to our motion for summary judgment.
Oh, well,
That is correct, Your Honor. I'll just speak briefly. In the beginning, Your Honor, we had a good faith basis to bring RV Share in. We anticipated that there was going to be some defect in design issues and also leasing the RV related to seat belts. There was a contention that there's not enough seat belts for everyone and that everyone should have been belted. However, through discovery, testimony of state troopers and that sort of nature, we do not believe that that is actually an issue here at this time. So we chose not to produce any type of response that would have some evidentiary support, seemingly because it wasn't there. And so I think Mr. Nunez summed it up pretty well, but I just want to let the court know that that is the situation.
okay. All right, then obviously that is not opposed, so it will be granted. Thank you, Mr. Nunez.
Thank you, Your Honor. And Your Honor, I do have one question. There was a claim for a cross-claim for contribution filed by Mr. Rincon's office against my client. Would the court be dismissing that as well, or should I just file motions with the court as well, Your Honor?
So I would encourage you to file something. Just
Okay.
Good.
No problem, Judge.
Okay.
No problem.
All right. Okay. Yeah, I'm going to need a minute on Mr. Lopez and Mr. Cathay, unless you have something else for the court. I'm going to need a minute on your claim. Those are the only two items we were set for today, correct? Because I am seeing that we have several things filed recently.
Correct. Yeah, those are the only two that are noticed.
Yes.
Correct, Judge.
So I am happy to discuss anything in terms of a case status. But I'm going to need a minute on Mr. Lopez's summary judgment.
Okay.
Sure, Judge. And I know we're set, and sorry, Judge, I'm kind of jumping in for Dan on this case. I know we're set for I guess a final pretrial conference in a couple of weeks. I don't know if we've requested a hearing on the motion to sever and abate yet, but if we haven't, I'll make sure we do that.
So I don't believe you have. I saw, I think yesterday or the day before, that we'd had some recent filings, but honestly, I hadn't peeked in to see what was going on. The motion for severance was filed on the 6th.
Okay.
Other things. Court has some availability, so if you'll request your hearings here before the 4th of July holiday, I'd like to handle those before then, and certainly whatever date we pick will at least be my mental deadline on the motion for summary judgment. Motions for summary judgment.
Yes, Judge. We'll get that requested.
Okay. Anything else today?
No, Your Honor, I believe that's it.
No, Your Honor.
All right. We're out of trial now, so I think I can delve into some of these filings just to get a little heads up as to what you all have been busy doing. But if there's nothing further, then we have we'll have our next setting before the final civil pretrial. All right. Anything else?
Believe
No,
that's
Your Honor.
Your Honor.
All right, Mr. Nunez, you get me in order, please.
Yes, Judge, I will.
Thank you. Gentlemen, have
Thank
a
you,
good
Judge.
You too.
Thank you, Your Honor.
Take care.